bagenda tuula wano ndaba we bajja.
Good morning. Ab'essimu ennungi tugenda pago.
Counsel, slowly as we're doing this procedure.
Okay. Chintu Michael. Okay. Kato Wilson. Wimbaz Nalukola. Chiwanuka Abdala. Akachimpa Godfrey. Wanda Ronald Samuel. Ernest Kalibala. Frederick Jempanga. Ernest has moved. Okay.
Let us wait for you.
Perhaps you should add another shade here.
So the next day. So the political actors wait this first and this heavy come. What was good? Wait from there. Let us sort out this heavy come back. We shall come back for you. Press. But you must be given to enter. Let us come for you now. This is good. Yes, but we don't have the direction. Can you have a system? Let's have somewhere. We shall kindly.
I don't want to see.
Even who can understand?
Just clear. I don't want to stand here.
You stay here.
It's okay. Parents sit first, the public sit, the lawyers come, and the chairman comes. But for you, you do it the other way around.
That's my procedure, not our procedure.
If you are court, you must behave like court.
Maybe we have you must, but what's important, you go to the court.
So who has the list of parents?
I'm the one. I'm the doctor. After lawyers, doctor. What's going to happen is that we are going to allow the political leaders. Let you know. So, and the rest, parents, you also enter. And even the public, not only the category. So, yeah. So allow me to invite the political leaders.
And the aunties.
Grandmothers. Political leaders only.
How about the daughters?
Daughters will come after, please. If I say political leaders, yeah. One by one.
Katimani na kasao.
My name is Ernest Kalibala. I appear under the leadership of Senior Counsel Martha Karua, together with the Honorable Elias Lukwago, Mr. Tugume Moses, Ms. Kunihira Proskovia, Mr. Silas Ogul, Mr. Peter Arinaitwe, Mr. Bayan Turinamukama, Mr. Tumusime Kato, Mr. Michael Chintu, Mr. Abubakar Sekanjako, Mr. Kato Wilson, Mr. Luyimbazi Elias Nalukola, Honorable Abdallah Chiwanuka, Mr. Akachimpa Godfrey, Mr. Wanda Ronald Samuel. Some housekeeping issues that we request to be dealt with before we proceed, if the chair may allow us. Be handled by my colleague, the Lord Mayor. Starting off with Senior Counsel Martha. I apologize, Senior Counsel.
Case we are handled.
I believe it is, Mr. Chair.
Please, the court, one of the housekeeping issues is regarding our right of access to the court as advocates representing the suspects in the dock. And looking at regulation number 60 of Uganda People's Defense Forces Act, regulation number 1. This regulation gives you, Mr. Chairman, the duty to ensure that this court functions as any other court of law. And in any court of law, advocates are granted access to the court to be able to do their duty to represent the accused persons. Because of what transpired here last time we were here on the 10th, when Eron Chisa was denied access and it resulted to him being jailed, we are most humbly seeking your assurances that as advocates, we are not going to endure any intimidation or obstruction as we come into court to do our duties. I must state that what transpired has caused a lot of shock. If you can see, we are lesser than we normally are. It has caused fear and intimidation among the ranks of advocates, and we thought that we needed to bring to your attention that this court needs to show and to demonstrate balance, not just the welfare of the military officers before it, but the welfare of everybody in its presence. So we are seeking assurances that we'll be able to represent our clients without intimidation. And today I must state that we had ease of access unlike other days, because we also want to be upfront. Today we have even been facilitated to sit together where we can be able to pass notes to one another. We thought we should bring that. The other issue is of officers who are manning the court not having their name tags. So we are not able to know who is interacting with us, and it is necessary, because it's procedural, that any officer who is officiating at the court should be disclosed. An issue that is may not appear very relevant, but it is. We have noticed the changing composition of the court, that sometimes 1 or 2 members are replaced. And we are requesting when that occurs, kindly let us know who has been replaced and the names and the rank of the person representing them. You remember that at the start of the court, the names and ranks of all members of the court were read out. But at that time, these 2 gentlemen were not represented. So when they change, it throws us off balance. We are not able to know the composition of the court, which is a requirement. We have other housekeeping issues, which I'll leave my colleagues to add to. And maybe before he rises, to my colleague and professional colleague, the judge advocate, just to tell him that, yes, I'm from Kenya, but I'm an East African and have an East African passport. So the unkind reference of me as a foreigner is not last time. It's not applicable. I'm an East African holding an East African passport. So apart from being licensed to practice law here, I come as of right being an East African. There is one other issue that I was required to mention before I hand over to the Lord Mayor. It's just about the terminologies. The last time, the judge advocate actually said that I could also be subjected to contempt proceedings for referring to this court as a tribunal. Whereas we are trying our best to keep saying court, I just wanted it to be on record, Mr. Chairman. The word tribunal is not derogatory at all. Tribunal refers to a court in the Oxford Dictionary, and I hope my team has come with the photocopy. It refers to a specialized court, like yourselves, which is dealing with a specific court, a specific matter. You are not dealing with the general matters. For instance, a Ugandan who is a landlord cannot come and file a claim against the tenants before yourselves. You are set up for a particular purpose. That's what tribunal means. And therefore, I would plead with the judge advocate, please let us give the proper interpretation, because they are bound to take your interpretation if nobody objects. But if we object, then the court, led by the chairman, has a duty to see whether our objections are valid. So I would like to refer to the English dictionary and says...
Maybe for me, if I may interject, the word court is defined in the UPDF Act. We are not going to adapt the dictionary definitions. Use the UPDF Act to define what is the meaning of court. That is the one we shall go with.
That exactly is our problem.
Which was enacted by the parliament.
It is true.
So outside that, unless you go back, I started from there.
Mr. Chairman, we seek your indulgence in listening to our objection. The English language is neither defined by the UPDF Act or even by the Constitution of Uganda. The English language is a foreign language, and meaning is found in either legal dictionaries or reputable dictionaries in the world. And therefore, the word tribunal, court, which is an English language word, must be defined. And I say Article Rule 60 places a responsibility on the chairman to ensure that this court functions like other courts of law. We actually quote those dictionaries every day. In the courts in Uganda, in the courts in Kenya, in courts anywhere in the world. And I invite you to check the word tribunal so that we do not undergo threats of being imprisoned for using the word tribunal. It's not derogatory. It can be used interchangeably. And what I'm really hinting at is that the interpretations of the judge advocate must be as closely as possible to reality to avoid misleading the court into acting in a manner prohibited by the Constitution of Uganda. I hand over to my colleague.
Thank you, Mr. Chairman and members. Mr. Chairman, I just want to substantiate these issues with prayers. Number one, Mr. Chairman, the issues raised by Senior Counsel are quite fundamental in the administration of justice before you, or by this court-martial. From the list read by my friend here, Counsel Karibara, the name Eron Chiza remains on the list as one of the advocates representing their chosen persons. Mr. Chairman, we seek your guidance on how that is going to be handled, because the instructions still stand that it should be part of the team, despite what transpired the last time we appeared here and the proceedings of this honorable court. Mr. Chairman, we are wondering whether there will be orders that every time the proceedings come, you have discretionary powers to direct that he be produced here to execute the duties, and then maybe he's returned. But we leave it to you, Mr. Chairman, to guide us on how we are going to deal with that, because it's a matter which touches on the right to legal representation, which is an integral part or a key ingredient of the right to fair hearing enshrined in Article 28 of the Constitution. And as we indicated earlier, there is a specific role he had been assigned in representing their chosen persons. So we beg to be guided, Mr. Chairman, on how Eron Chiza is going to continue featuring in these proceedings as one of counsel. And we ask that you pronounce yourself on this particular matter too. Again, we do ask, Mr. Chairman, that you pronounce yourself on the validity of the proceedings conducted when the tribunal, rather the court-martial, the panel changed. When the panel, the composition changed. Because as per Regulation 26, Mr. Chairman, the sub-regulation 1, the order convening the court and the names of the officers appointed by the accused person shall be read in the hearing of the accused, who shall be given an opportunity to object to any of those officers. Indeed, at the commencement of the proceedings on day 1, the names were read. But subsequent to that, as highlighted by my senior colleague here, the panels kept shifting. So the panel that was announced on day 1 is the panel that ought to have continued. Even on the day Eron Chiza was tried, summarily and convicted, it was a totally different panel. So, Mr. Chairman, we beg that you pronounce yourself on the validity of the proceedings that transpired after the panel had changed. And that is also fundamental in line with Regulation 26 of the regulations of this court-martial. Now, on the question of intimidation of lawyers, it's a very serious one, Mr. Chairman. We beg that you critically reflect on this. We are concerned that the war environment is not conducive for dispensation of justice. As she has noted, and we're on record. You can see our numbers are shrinking. They are shrinking because of the intimidation which is going on. There are orders that were made earlier by you, Mr. Chairman, that all the officers manning the processes right from the point of entry should be clearly identified. They should have name tags. But we continue to have officers who are hooded, whose face you cannot even recognize, who have no name tags. So we don't know who we are dealing with, Mr. Chairman. And this is a known practice. I can see, Mr. Chairman, members who are part of this tribunal, Mr. Chairman. Their names were announced to us. And it's not without a reason that that provision was enshrined in the rules governing the proceedings before you. Why should we continue to have officers all over manning the courtroom here, manning the premises, handling all these the protocols here we go through, you cannot easily identify? And they create the environment to be very, very inimical to dispensation of justice and very hostile, Mr. Chairman. And this is a key tenet of the due process, and it's a key tenet of the right to a fair hearing, which is the bedrock of our criminal justice system in this country. May we request that, Mr. Chairman, you make the environment conducive for administration of justice. It's a well-known principle, Mr. Chairman, that justice must not only be done, but should also be seen to be done. So it should be manifested in the proceedings, in the way all the processes are conducted, and in the way we are treated. But, Mr. Chairman, the perception, and the reality is no conducive environment. And finally, Mr. Chairman, on the nomenclature here, which is turning out to be controversial, the issue of the tribunal. I thought they wouldn't be fuss about it, because we use these terms interchangeably, even in the courts of judicature. Mr. Chairman, it has happened even in the Supreme Court to refer to the Supreme Court as a tribunal, to refer to a Chief Justice as an arbiter. And the Chief Justice does not take offense. And to refer to his office as an arbiter, or to refer to him as an arbiter, the Chief Justice does not take offense. The ordinary courts of law do not take offense being referred to them as. Now, I'm worried if that is going to invite disciplinary proceedings, just even if it's a mere slip of tongue anyway, that is going to invite disciplinary action. That sends chills down our spines, and it has a chilling effect on the execution of our duties. That chilling effect is so fundamental in the dispensation of justice. If I may ask, Mr. Chairman, I have had some of the officers here addressing you as your lordship. They are saying, my lord, my lord. Yet, for us, we are addressing you as a chairman. Would that also be taken to be undermining this court, that we're not addressing you as my lord, that we're addressing you as Mr. Chairman? I think the judge advocate and the entire panel shouldn't take offense about this. We can interchangeably refer to you as a court, we can interchangeably refer you as court martial or as a tribunal, because they all mean one and the same thing. But one fact remains, if we are talking about courts of judicature, that's a different matter, Mr. Chairman, because courts of judicature are well defined under the Judicature Act. So, Mr. Chairman, I beg that you do pronounce yourself on those matters, because they are fundamental on the dispensation, in regards to dispensation of justice.
who are manning the security. But on that one, I can't tell much about that because by the time I first there was nothing. But if I'm not mistaken, I may add this with intimidation. The council have talked about much as you want to blame us in almost all issues. I think somehow some of you need to blame yourselves. Council you have been talking everywhere what you are intending to do. And I think it cannot be taken lightly. Because we need security. People who come here need security. And we don't know the tactics you want to use to destroy this code. We don't know. So security also have to check if they have been checking people who are coming. I think that's what it's all about. Because I don't know what they were asking you, what they were telling you, I can't tell. But I believe it could have managed maybe from those statements you make. And on Counsel Eron, I don't know really what you are pushing, because I've never had, unless you will guide us also on that one. A person who is serving a sentence come and attend the court, that one I don't know. Can be advised on that. As senior counsel, I don't know, you said, I don't know where this one came from. We know, of course, you are from Kenya, and Kenya is part of the East African community. So I don't know that one where it came from. But I think even a villager, once you say I'm from Kenya or Tanzania, they know. It's good you have talked about the context today. And you remember it was already the other time. You said I want to talk to these people. And that's what we want. We are not here just to, it's not a war. And I don't know why you are looking at one side, you are not looking at another side. For making noise in the court. To the extent of even of standing on the chairs which are not supposed to sit where they are supposed to sit. Singing, is that a court? Or you want to make us, you are either provoking us or you are, I can't tell why you are doing that. What we need is to conduct yourselves in the manner you are supposed to conduct yourselves. This is a code. I've seen it everywhere. Once a council or anybody submitting, everybody is listening quietly. You finish another one. If this side finishes, another side also, so that we proceed without any problem. It talks about the duties of the judge advocate. Regulation 1 says that the prosecutor and the accused respectively are at all times after the judge advocate is named to act at the trial, entitled his opinion on any question of law or procedure relative to the charge or trial, whether he is in or out of court, and the accused and his lawyer. That's what it means. So any legal issues arising, I am mandated to advise this court. To begin with, holding this court a tribunal, that one will not happen. The UPDF Act defines court-martial as a field court-martial, general court-martial, or court-martial appeal court. That is what a court martial is. Even in the constitution, it is there that you can, the DPP can have intend over all proceedings apart from the court martial. So to say that we are going to borrow definitions or to have slips of tongue, I think me as the judge advocate of this court, you must call this court a court martial. That is the name that is in the UPDF Act. We are not going to adapt dictionary definitions. Secondly, the issue of Eron Chiza as one of the lawyers. I also direct you to read Article 28, Clause 3, Clause D. Sometimes I never to read because when I refer to read, they say I should read. So I will read. It says every person who is right, that's the right to a fair hearing, every person who is charged with a criminal offense shall, when you go to be permitted to appear before the court in person or at that person's own expense by a lawyer of his or her choice. I don't see where they have said lawyers of his or her choice. And in as far as I know, in all cases we have handled. However, gravity of the offense, you cannot say that when we have 30 lawyers here, Eron Chiza, who was convicted by this court, is not there, and therefore the right to fair hearing is violated. Then what would be your role here? All the lawyers who are here, if I may ask. Or can I say you are going to say it's a constitutional violation because a person who was convicted before this court is not there and all the over 30 lawyers are here, that the right to doctor is violated? Yes. My answer is no. And if you want to seek constitutional interpretation, you can seek a constitutional reference on that. My understanding here, they say a lawyer of his or her choice. You can have more than one if you can, but to say you can be 30 and Chiza has a specific role, to me that doesn't make sense. I think I'm done with that.